to make the law. The court held that Section 12 was repugnant to Section 3 of the Constitution and was struck down. That is as far back as 1982. Now, then this is what we call dealing with a private individual with a civil matter. In 1993, this is another case where this time the Attorney General entered a case against Mr. Navin Ramgoolam, who was the leader of the opposition at that time and now the Prime Minister of the country. What happened in that case? I mean, I did not bother you with all the intricate details of the case. Suffice it to say, to state the point that it concerns an application made by the Attorney General for a determination as to whether the seat of Mr. Ramgoolam had become vacant on account of Desire 1E of the Constitution, that is, the vacancy has occurred because Mr. Ramgoolam has, without leave of the Speaker, previously appointed, again, been absent from for the sitting for a continuous period of 3 months during the same session and for a reason other than his being in lawful custody. Now, in fact, Mr. Ramgoolam was indeed not present for 3 months, and he hasn't applied for it in order to fulfill overseas commitment and complete his studies. This is what the learned judge had to say. I quote, we need say no more than that. Where Parliament exercises sovereign powers under the Constitution and the courts are empowered to exercise a particular jurisdiction, which itself requires an inquiry into the exercise of these powers by the Parliament, then the jurisdiction of the court must be exercised to the appropriate extent in order to enable to determine the particular question that's before it. It would be misleading in those circumstances to invoke the sovereignty of the National Assembly, which will have the effect of paralyzing the effective exercise of the constitutional jurisdiction of the court. The Supreme Court held that the right of a member to sit in Parliament is a constitutional one. It can only be removed within the strict...
To be answered by him and his friend, Mr. Grave. That's the reason I request the next speaker, Mr. Andre Benagoni, law officer, Brussels, to speak. 5 minutes, 10 minutes? 10 minutes. 10 minutes. I request him to complete it by 10 minutes. Thank you.
You can come on the dais. It is better. He will come down.
Okay.
Thank you very much. First, I would like to begin by thanking all of you for the kind invitation. It's really an honor and a pleasure for me to be here to attend this interesting conference. I think I've been invited to share with you my personal experience that at the moment is an experience on 3 issues. Because basically I'm an Italian prosecutor, so I'm a member of the Italian judiciary, but at present I happen to be seconded as national expert to the European Commission, to the European Anti-Fraud Office, and at the same time I also happen to be a member of an independent international commission which is tasked with with carrying out a complete vetting process of the judiciary in Kosovo, in the Balkans. So I'm going to speak very briefly, as I promised, about this.
Justice Tandon. No, Justice Tandon earlier, and also Judge Tandon. And also.
सर आपको इधर आना पड़ेगा कि तो आपका स्क्रीन बन गया मुंह इधर इस साइड में.
Motions, petition, as well as writ. So it will be interesting for you to comment on that later. But before that, I'll get Mr. Fernandez to make some observation and some.
I think we had a very good morning, a thrilling and scintillating experience with 2 expert honorable judges from India. And as I mentioned at the outset, because IT should be used to not only deliver justice, but to dispense justice. At the moment, we are talking of maintaining electronic records and transmitting these records. I think it will be appropriate for us in here to see that audio-visual electronic
computer which can have provision of internet or which can have a good memory. So we, under the banner of All India Bar Association, with the help of American Bar Association, because American Bar Association is having a proposal to spread ICT, not only in the courts, because it is mandatory that the lawyers should be aware of this ICT. So when every lawyer or every bar association is having this facility, then my lawyers can have e-filing. Because having e-filing for some matters, only one party is filing the pleadings by e-filing and others is not, then there is no utility. Then you are spending double. Because you are making provision for e-filing, you will be having, courts will have activities, but other party is not filing. This is correct. Without e-filing also it can be, a court can make, but it becomes difficult for the courts. Because when printed document is coming to court, then the staff has to scan it, and scanned file is very heavy. If e-filing is by word file, then it is very not so much weighty. So preserving that document, file on computer is very easy if both the parties, all the parties in a case, they there is
our next memento to the Chairman, Justice Hariom Emi, Judge, High Court, Brunei.
Thank you.
Next, memento to Honorable Mr. John F. Fernandez, ex-Member of Parliament.
To Honorable Mr. Judge, Mr. Talwanse. Yeah.
Thank you.
Yeah, that's it.
thank you. Thank you.
Okay,
Thank you.
okay, the sitting is adjourned.
This topic not necessarily legal. There may be social aspects, there may be various issues, maybe on health. I remember one time we were talked on the subject of our own physical well-being. And we call health experts, come and talk to us, and we are able to be exposed to other aspects of life, which otherwise we would not, because we are not free to circulate or interact with the other people for fear of what we are talking about. People talking to you, say, okay, I have a case, could you please do this, do that, I need assistance from you, and that sort of thing. We fear free interaction for that particular reason. So that way we are able to learn and to educate others, because that's a difficult area. We were considering the question of putting the judges into residence and teaching them. I thought that it would be demeaning to put a judge in class and teach him as you would teach, say, a student who is in law school. And so it's thought that judges are mature people, they are responsible people, so you cannot teach them like kids. Recently there was a move to have distant learning. Some judges have expressed a wish to pursue further education roles. Many of the lecturers are also advocates. And if the lecturer were to appear before you and you to be in his or her class, it might not...
Keeping the privacy and the confidentiality of the transactions and meant for facilitating the parties to have free choice in the matter of a person named to adjudicate the kind of jurisdiction that they would get into, the kind of set of rules they would like to adopt, and so on and so forth, has ultimately resulted in taking, if not equal, a good amount of time of the court on account of what is known as what precisely was ad idem between the parties at the time when the contract was entered into. And therefore I say the alternate dispute resolution mechanism, insofar as arbitration is concerned, well, in this part of the country which I come from, and the High Court where I practice, as also the Supreme Court where I very often go to, has led to an equal number of disputes, if not an equal number, nearly an equal number of disputes, as to the meaning and intent of the parties, insofar as they invoke the arbitration process, which was available to them at the time when they go into the arbitration agreement.
Otherwise, they'll have no chance.
And therefore, I say that in addition to arbitration in the form that we have, which definitely, according to me, needs some more modifications with a view to
It has a committee called Legal Education Committee, which is normally headed by a retired Supreme Court judge, and on which there has to be a sitting High Court judge in its. The main task of the committee is firstly to decide as to what is to be taught to the law students, number one. Two, there must be a law professor, there must be a law faculty. Wherever the legal selection is going to take place, you must at least obtain the opinion of some law professor to understand the depth of that student, to see that that student has the basic concepts. He has the clear basic concepts. This is only one part. Again, we will have to rethink as to whether there has to be the crop of law teaching has to be more on the lines of creating and adding to the legal status, to the legal structure, to the lawyers' bar. My third point. Is the law education going to stop at the stage when we admit them to the bar? No. According to me.
Lordships, and I do not know what the policy of a senior Supreme Court judge. He is a jurist and also judge, and acknowledged, and rather he has manifested his interest for this legal education, not only by emphasizing yesterday and today he has certain problems and also solved them. And now Dharmo Rakshita Rakshita Shita. So everywhere we speak only Dharma and Dharma, Dharma. And education. Justice, education. Because Dharma is such. Dharmasya moolam artha. Arthasya moolam vinaya. Vinayasya moolam vijnanam. Vijnanasya phalam moksha. Moksha means salvation. It is salvation everywhere.